Picture this. You pull into a parking spot, step out of your car, and you look for a meter.
Right, the classic scenario.
Yeah, exactly. But there is no meter. There are no hourly rates posted. No rules at all.
Oh, just the sign.
Right. Just a metal pole, a corporate logo, and a giant QR code that's basically commanding you to download an app.
Which, we have all grumbled about.
Oh, absolutely. You probably just download the app, complain to whoever you're meeting for coffee, and move on with your day.
Right, because what else are you going to do?
Exactly. But today, well, we're looking at one Florida citizen who didn't just grumble. He actually built an intricate legal trap to bring this entire multi-million-dollar system crashing down.
Yeah, and the citizen is a senior named Kerry Lutz. And what he is doing here goes way beyond just a typical consumer complaint.
Right. It's definitely not just a Yelp review.
Not at all. We are examining a thick stack of his recent legal filings from April and May of 2026.
So what exactly are we looking at in these filings?
Well, it includes 5 distinct rulemaking petitions sent to the Florida Chief Financial Officer, plus an emergency declaratory statement petition filed with the Florida Department of Transportation.
Wow, okay.
Yeah, and the underlying Florida statutes that make this all possible, specifically chapters 120, 215, 218, and 316.
Okay, so before we really jump in, we should probably set some ground rules for this deep dive.
Yeah, good idea.
Our mission today is not to debate whether app-based parking is inherently good or bad, right? We aren't, taking a stance on urban planning or technology.
No, definitely not.
Right. We are looking at these documents because, well, they represent an absolute masterclass in citizen empowerment and administrative law.
Which is fascinating, regardless of how you feel about the apps themselves.
Exactly. We are just going to analyze how a single person is using the state's own procedural rules to effectively corner these massive government agencies.
And Lutz's strategy is incredibly methodical. I mean, he doesn't start by attacking the software itself or even the concept of parking fees.
Oh, really? Where does he start?
He starts by attacking the physical signs planted right out on the street.
Okay, that makes sense.
Yeah. So in May of 2026, alongside a group called the National Association of American Defrauded Parkers, Lutz basically targeted the Florida Department of Transportation, or the FDOT.
Right, the FCO2.
He zeroes in on Florida Statute 316.0745. Now, this law mandates that Florida must adhere to a uniform system of traffic control devices.
And that's based on a federal standard.
Exactly. It's a federal rulebook known as the MUTCD.
Okay, let's break that acronym down for a second. The MUTCD is the Manual on Uniform Traffic Control Devices. Right. It's basically the engineering Bible for, every stop sign, speed limit sign, and crosswalk in the entire country.
That's a great way to put it. Yeah. And the whole premise of the MUTCD is safety through uniformity.
Like everyone needs to understand it instantly.
Yeah. For a traffic control device to be valid at all, it has to convey a, quote, clear, simple meaning. A driver needs to know exactly what the law requires just by glancing at the sign.
Okay, and I'm guessing Lutz argues that these app-based parking signs completely fail that legal test.
Absolutely. He points out that they withhold the actual regulatory text, the hourly rates, the time limits, the enforcement hours.
Because it's all trapped behind a digital wall.
Exactly.
Because, the sign usually just says, scan here to pay. To actually find out if parking costs $1 an hour or $10 an hour, you have to pull out a smartphone.
Yep.
And then download a third-party app, create an account, and agree to their terms of service. You literally cannot know the law just by looking at the sign.
You can't. And furthermore, Lutz layers in Florida Statute 316.077.
What does that one do?
This statute explicitly prohibits any, quote, commercial advertising on a traffic sign.
Wait, so...
Lutz points out that the logos for these private companies like Park Mobile or Pay by Phone are registered trademarks.
Oh, I see where this is going.
Right. Placing corporate branding directly on official government traffic signs is, according to the plain text of the law, commercial advertising.
Wait, let me make sure I'm following this logic. If I bolt a speed limit sign to a pole on my street, but I add the words, sponsored by Coca-Cola, the state would tear that down immediately, right?
Oh, in a heartbeat.
Because you can't put private ads on public traffic controls. So is Lutz basically arguing that an app logo on a municipal parking sign is legally indistinguishable from, a Coke sponsorship?
Yes. Under the strict definition of the statute, commercial branding is commercial branding. If a logo advertises a private company's service, it is straight up prohibited on an official traffic control device.
That is wild.
Because these signs violate the federal MUTCD by hiding the rules, and they violate state law by displaying commercial ads, Lutz argues they are legally defined as public nuisances.
Meaning what, exactly?
Meaning they are entirely unenforceable under Florida Statute 316.074, subsection 3.
Okay, but if these physical signs are so blatantly violating the rules, why would a local city risk putting them up in the first place?
That's the big question.
And why is Lutz taking this all the way to the Florida Department of Transportation instead of just, fighting a $20 ticket in traffic court?
Because the stakes at the state level are massive. The FDOT is the agency responsible for ensuring compliance with federal highway standards.
Right.
If the FDOT officially admits that these municipal parking signs violate the MUTCD, well, Florida risks losing its federal highway funding under Title 23 of the U.S. Code.
Wait, really? We're talking about, what, billions of dollars in infrastructure money?
Exactly. Billions. But on the flip side, if the FDOT ignores the violations just to protect the local cities, they are openly defying their own state statutes.
Wow. So he's put the Department of Transportation in a total bind over the physical signs.
A complete lose-lose for them.
But, that physical sign is really just the bait, isn't it? The real trap is the whole financial ecosystem operating behind that QR code.
Oh, absolutely.
I mean, if cities are willing to risk federal highway funding to keep these signs up, there has to be an enormous financial motive behind it.
Always follow the municipal money.
Right.
Having cornered the FDOT regarding the physical streets, let's pivot straight to the municipal ledgers. In April and May of 2026, he filed a series of 5 very specific petitions with Florida's chief financial officer, Blaise Ingoglia.
Okay, so he's elevating this to the CFO now.
Yep. He shifted his legal foundation to Florida statutes 215 and 218, which govern municipal finance, internal controls, and state revenue.
Let's walk through these 5 CFO petitions because this is where the financial mechanics of these apps really get exposed.
Yeah.
He starts with the zero-cost app mandate and the surcharge ceiling petition, right?
He does, and those heavily rely on Florida Statute 215.
Okay, so what does 215 actually say?
It dictates how local governments can accept electronic payments. The law states that convenience fees are only supposed to cover the actual cost of processing the transaction.
So if it costs the vendor 10 cents to process a credit card, the fee should be 10 cents.
Exactly. But Lutz provides evidence in his filings that third-party vendors are charging convenience fees that wildly exceed those actual merchant costs.
So they're essentially turning a basic administrative fee into an unauthorized secondary revenue stream.
Yes, exactly.
Which operates like a hidden tax on the citizen that the city never even had to vote on.
Right. It bypasses the whole democratic process. And then he introduces the transparency or insolvency rule.
Oh, this one is fascinating.
Yeah. In this petition, Lutz attaches an exhibit from a vendor proposal made to the city of Delray Beach involving a private company called One Parking.
I remember reading this.
This document exposes the internal mechanics of a revenue share model between the city and the tech company.
I really want to focus on this part because the math here is just wild.
Yeah.
How does this revenue share actually function behind the scenes?
Well, according to the exhibit Lutz provided, before the city government even sees a single dime of a parking fine or fee, the private vendor takes a massive cut directly off the top.
Off the top, wow.
In this specific Delray Beach example, it's a 25% tech fee.
25%.
Yep. That money is diverted straight to the private company's bank account before the remaining balance is ever deposited into the city's ledger.
Before it's even subjected to the agreed-upon revenue share.
Exactly. So Lutz argues this creates a predatory financial incentive that violates the internal accounting controls mandated by Florida Statute 218.
Which perfectly explains his next petition, right?
Yeah.
The anti-privateer standard.
Right, the anti-privateer standard.
He basically wants the state to mandate that parking citations can only be issued by W-2 government employees.
And that W-2 designation is critical here. A W-2 government employee is directly accountable to the state, paid a set salary, and bound by public ethics laws.
Unlike a private contractor.
Right. Lutz wants to completely ban per-ticket bounties or revenue-sharing incentives for private companies.
Because of the conflict of interest.
Exactly. When you monetize the police power of the state for private profit, you introduce a severe conflict of interest into the equitable enforcement of the law.
Wait, so the city is basically outsourcing its police power on a commission basis?
That's his argument, yeah.
That makes these apps sound like, digital bounty hunters.
Oh, that's exactly what they are.
Because they only get paid their tech fee if a ticket is issued and collected, meaning their primary goal isn't public safety or traffic flow at all. It's just maximizing citation volume.
Digital bounty hunters captures the exact hazard Lutz is highlighting in these filings. By giving private vendors a financial incentive to maximize tickets, the city creates a system motivated purely by profit.
And that's why he takes it to the CFO.
Right. By framing this not as a local parking complaint, but as unconstitutional taxation and a failure of municipal internal controls, Lutz elevates it to the state's top fiscal watchdog.
He literally forces the CFO to look at how local governments are letting private companies skim public funds.
And, he doesn't stop with just the financial skimming. On May 3rd, he submitted 2 more petitions to the CFO.
Okay, let's hear about those.
One of them focuses on the protection of minors. He points out that these parking apps are rated 4+ or everyone on the App Store.
Which makes sense for an app.
Right, but teenagers are required to use them to park.
Okay, but what is the actual legal issue with a teenager downloading a parking app?
The issue is contract law. In Florida, a 16-year-old or 17-year-old licensed driver cannot legally enter into a binding financial contract.
Of course.
Yet, to park their car on a public street, the city literally forces them to download an app, agree to a complex terms of service, consent to data harvesting, and waive certain due process rights via forced arbitration clauses.
So the city is implicitly forcing minors into legally void contracts just to park.
Exactly. So Lutz proposes requiring these apps to be rated 18+ or requiring verifiable parental consent.
That is such a clever legal angle.
Yeah.
And he also filed a mandatory alternative payment rule, right, to stop what he calls a digital shakedown. Like, if you don't have a smartphone, if your phone battery dies, or if you simply refuse to agree to a third-party company mining your personal data, you are completely locked out of accessing public parking.
Which shouldn't be allowed for a public utility.
Right. So he wants to force cities to provide an analog, non-app way to pay.
And again, the target of these petitions is incredibly deliberate. Lutz isn't asking a local city council to change its mind.
Because city councils love this revenue.
They absolutely love it. He is arguing that the underlying financial architecture of these vendor contracts violates state law.
Okay, but come on. Let's be real for a second. Bureaucracies have teams of lawyers whose entire job is to swat away citizen complaints. They move at a glacial pace, and they are masters at just making paperwork disappear. How does he actually force the CFO or the FDOT to care about any of this? It's like, what stops them from just burying these petitions in a desk drawer for the next 10 years?
This brings us to the procedural trap. This is where Lutz weaponizes Florida's Administrative Procedure Act, or the APA, which is found in Chapter 120 of the Florida statutes.
Okay, Chapter 120.
The APA is basically the operating system for how the government makes and enforces rules. And Lutz is utilizing 2 very specific, very powerful mechanisms within this code.
Let's start with the first one, but before we get into how it works, what exactly is a declaratory statement? Is that like filing a lawsuit against the state?
Not exactly. It's different from a lawsuit.
Oh.
Under Florida Statute 120.565, a declaratory statement is a legally binding request from a citizen.
Okay.
You're asking a government agency to officially state how a specific law or statute applies to their particular situation. You are forcing the agency to go on the record with a legal interpretation.
Got it.
And the APA includes a mechanism we can call the shot clock. When a citizen files this petition, the agency literally does not have the option to ignore it.
So they are legally on the clock.
Yes. The statute dictates that the agency must issue a declaratory statement or formally deny the petition within 90 days.
Wow. 90 days.
They legally cannot bury it in a drawer. The law forces them to answer the legal question presented within a strict time frame.
Okay, so the state gets forced to respond within 90 days. But let me push back here a little bit.
Sure.
What's stopping the agency from just looking at the petition and saying, we reviewed your arguments, Lutz, and you're wrong. The signs are fine. The fees are fine. Petition denied.
Right.
I mean, they know he can appeal, but isn't the entire administrative court system pretty much rigged in the government's favor anyway?
Historically, yes. The system was heavily tilted toward the agencies. For decades, courts operated under a legal doctrine of deference.
Deference, okay.
Yeah, so if a citizen challenged an agency over the interpretation of a statute, the judge would generally defer to the agency's interpretation, assuming the agency bureaucrats were the, quote, subject matter experts.
So it gave the state a massive home field advantage in any legal dispute.
Basically, the agency was allowed to grade its own homework. If the law was ambiguous, the agency got to decide what it meant, and the judge would just nod along.
That sounds incredibly frustrating for a citizen.
It was. But in 2018, Florida voters passed a constitutional amendment, Article V, Section 21.
And what does that do?
This amendment formally ended deference in Florida. Now, state courts and administrative law judges must interpret state statutes and rules de novo.
Novo, meaning like from scratch.
From scratch. An administrative law judge now has to look at the plain text of the law and decide what it means independently without giving the administrative agency any benefit of the doubt.
Oh, wow.
The playing field between the citizen and the state is completely leveled now.
Okay, wait, let me get this straight. Lutz files these petitions, and the APA shot clock means the agencies are legally forbidden from ignoring them.
Right. They have 90 days.
So door number one, if they agree with him, they have to declare the signs illegal, which instantly angers dozens of municipalities who stand to lose millions in app-based parking revenue. And it forces cities to tear down thousands of signs.
That is one highly destructive outcome for the state, yes.
Okay, so door number two. The state issues a statement saying the signs and fees are perfectly legal.
Right.
If they do that, they are officially on the record blessing traffic control devices that clearly violate federal MUTCD standards, which angers the Federal Highway Administration and puts billions in federal highway funding at risk.
Also a catastrophic outcome for the agencies involved.
Which leaves door number three. They just deny the petition, say Lutz is wrong, and tell him to go away.
And what happens then?
Because of the end of deference, Lutz immediately appeals to an independent administrative law judge. And that judge reads the strict, plain wording of the MUTCD and the state advertising statutes with zero deference to the agency's excuses.
Exactly.
The judge sees the commercial logos, sees the hidden regulatory text, and strikes the signs down anyway.
You've got it perfectly.
If they ignore him, they break the law. If they say he's right, cities lose millions. If they say he's wrong, a judge overrules them. They have literally nowhere to hide.
He has engineered a brilliant, inescapable trap. I mean, he found the vulnerabilities in the state statutes, mapped them against federal regulations, and applied pressure using the APA exactly where the system is forced to respond.
That is just incredible. So what does this all mean for you listening to this deep dive?
It's a really important lesson.
Yeah, this isn't just a story about parking. It's a blueprint. It proves that you don't need to be overwhelmed by government bureaucracy, and you don't need to be a massive corporation with a skyscraper full of lawyers to fight City Hall.
I know.
Understanding the operating system of your state is profoundly empowering.
And this is highly relevant for small business owners and everyday citizens alike. When you understand the mechanics of administrative law, like the 90-day shot clock or the end of deference, you realize that agencies are bound by strict procedural rules themselves.
Right.
Knowledge of those rules allows a single citizen to hold the government strictly accountable to its own laws.
It changes the entire dynamic of power. But before we wrap up this deep dive, I want to leave you with a massive, unresolved implication to ponder.
Oh, this is the best part.
It builds on everything we've just uncovered regarding how these signs are legally categorized.
The ripple effect of proving these signs are invalid.
Right. Let's look at Florida Statute 316.074, specifically subsection 3. That law states that no traffic provision can be enforced against a violator if an official traffic control device is not in proper position and sufficiently legible.
Meaning, if the sign doesn't meet the legal requirements, the ticket is invalid. You cannot enforce a rule based on an illegal sign.
So think about this. If Carrie Lutz successfully proves that these app-gated signs are illegal public nuisances, littered with unauthorized commercial advertising, well, what happens to the tens of millions of dollars in fines, convenience fees, and towing charges that have already been collected from citizens over the last few years? Yeah. If the signs were void all along, does this spark the largest retroactive refund in municipal history?
It introduces an astronomical liability for every local government that adopted this technology without actually checking the underlying statutes first.
So the next time you pull into a parking spot and see a corporate logo and a QR code, you might just be looking at the single most expensive administrative mistake a city has ever made.